Give it a day or so. Okay.
Todd, you want to go before or after? I'm not going to do the same bill. Okay. So it didn't matter. Excuse me.
Kept the second line right, so it's going for $100 bill right now.
I like it.
Closer we
It's like that seated Delta where it's like, all right, listen, we're getting $600 right now to give up this $700. Who wants to get off the flight first? I probably will.
These guys keep writing four. Oh, there's two against. There we go.
I feel like I'm all up on you here. I apologize.
Is there a sign-up sheet? Is that a sign-up sheet?
Yeah. I'm gonna put it. He said I could get it ready. It's not uncommon, but
We don't have many major issues. I mean, I know a lot of people who are rich, why do we not? I said, these individuals, they have something to get across. If we can't get 3 minutes, that's limited. I say it doesn't matter whether we like what they say, but guess what? They at least have the opportunity to get it off their chest. I get the
Congratulations on 8-8.
Thank you.
The Valdosta Chamber was very happy.
Thank you. I appreciate that.
I look at it.
Unanimous, right?
Yes, it was.
I want you to meet City Councilman Tim Carroll from Valdosta. Very hard.
Former chairman of the board, Virginia.
Yeah, I got to thinking about it. I mean, like, this is really almost a decade of this issue.
Sorry,
Good afternoon, everybody. We're going to go ahead and get this meeting started. We'll call the Governmental Affairs full committee meeting to order. We have a quorum, and I'm going to ask Vice Chair Victor Anderson to open in prayer.
If everyone will bow with me, please. Dear kind and heavenly Father, God, we thank you, Lord, for the opportunity to stand before you, God, and represent the citizens of the state of Georgia, God. We ask for your wisdom, your guidance, God, and your discernment as we go forward in this matter. In Jesus' name we pray. Amen.
Thank you, Representative Anderson. And so we have, let's see, 4 bills on the agenda today. And I know the hour's late. A lot of these bills we've already heard a lot about, and so we will try to keep, the tempo going pretty good. I know a lot of people have traveled a long way and waited a long time to be here. So we're going to start with Representative Scott Holcomb's bill, House Bill 1318. If you'll come up to the podium and tell us what your bill does.
All right. Thank you, Mr. Chairman, members of the committee. Believe it or not, for fun, I read the official code of Georgia annotated, and while doing so, I came across some sections that we don't do anymore, and specifically, I found that on page 7, there's a whole code section on the Georgia Rail Passenger Authority Overview Committee, and nothing's been done with that for more than a decade. So I filed legislation to repeal it since we don't do anything on it, and it's basically dormant and latent. And then through that, the Speaker's office coordinated with me, and there are a number of other aspects of the code that either needed to be renamed. For example, a committee of the Senate needed to be renamed, and that's in Part 1, Section 1, and then other parts have either updates of chairman to chairperson, and striking parts of our state government that don't exist anymore. And so really what it is it's an updating the code to reflect how we actually do business. And one very quick thing that I would point out, because I think we had a similar measure about this a year or two ago, is there is a line out on the Office of Women's Health, and you may remember a debate about asking specifically about that. This does not get rid of the Office of Women's Health. That still exists. This just removes them from the list that has to create reports and compile data, because in 2019 we eliminated that role and responsibility. So what this does is it just again reflects what the current roles and duties are for each respective agency. So we could go through them sort of line by line, but that's generally what it is, and it's been double checked. So I think it's all up to speed. Thank you, Mr. Chairman.
If I'm not mistaken, there's a Senate bill that's crossed over that had some of this same language in there.
Exactly, and that's what this reflects. That's exactly right.
All right, very good. We have a question from Representative Gullett.
Thank you. Repeal is a good word back home for my constituents, and I appreciate you shrinking government. Thank you.
Thank you.
I don't see any more questions, and trying to turn your mic off. Got it. Yeah, I don't see any more questions, and I don't believe anybody signed up to speak on this bill. So what's the will of the committee? All right, we have a motion to pass. Do we have a second? We have a second. All in favor say aye. Aye. Any opposed say no. All right, it moves. Thank you. All right, next I'm going to present House Bill 1407. 1407 is a result of a study committee that I co-chaired. It was a joint study committee, House-Senate study committee. So I co-chaired this along with Chairman Senator Frank Ginn. And we had, I believe, 5 meetings around the state over the summer and fall, and came up with a list of 7 recommendations to improve service delivery strategy. Because I'm not sure how familiar everybody is on this process, but there are situations in our state where counties and cities have had negotiations go on for years and years and cost hundreds of thousands, even millions of dollars in negotiating over a long period of time. And so what we did was come up with these recommendations to try to help local governments with these negotiations and put some more framework around them. And one of my favorite, I guess, recommendations and measures we put in the bill that we're going to present today is a provision that there was really no consequence to local governments for not coming to an agreement that served their citizens well. And so some of the local governments were just staying in disagreement for long periods of time. And so we have a section in the bill that imposes sanctions on the local governments if they're unable to reach a consensus within 6 months of the triggering event. And in the past, a judge could issue an abeyance. In this bill, that abeyance is no longer available. So the local government will lose their local government status if they are out of compliance, and which means there's a consequence now. And what I want to do is ask ACCG and GMA to come up to the podium, if you don't mind both coming up together and walk through the bill with me. The good news is that after a lot of negotiation over the last few months, weeks, days, and even hours, we believe the parties have come to agreement. And so if you don't mind, just whoever wants to go first, just kind of start and hit the highlights of what we've agreed to, and we'll try not to prolong it any more than we need to.
Sure. Good afternoon, everyone. Clint Mueller with ACCG. I want to thank Chairman LaHood not only for bringing this legislation, but for co-chairing the study committee that met over the course of last year to look at this issue. It's never good when your counties and cities are fighting over anything. When that gets into the press, as you all know, that's not a good look for your community to see counties and cities fighting. Unfortunately, some of these SDS negotiations have been contentious. So what we're trying to do with this legislation is limit some of the contentiousness, put parameters around the negotiation, so if certain things are not done at a certain time, everybody knows what the consequences are. So I think you'll find that this legislation deals mostly with the process of the negotiation. There are policy questions. There's some of those policy questions that are currently in litigation right now before the Georgia Supreme Court. We made the conscious decision not to try to address all those policy issues. We want to see what happens with this case before the Georgia Supreme Court, and we may come back in the future and try to address some of the policy issues. So this bill is really about the process and trying to make the process better. And like Chairman LaHood says, if there's no deadlines and no consequences, people will just never comply. And that's happened in some places, so that's in here. And I think the arbitration process in here, although it's non-binding, will be a big incentive for people to come to the table and negotiate in good faith. And we've got other things in here to help. It's all about good faith negotiations. So everybody shows all their cards up front before they go to an arbitrator, and that people aren't trying to sneak something at the last minute. Everybody knows what the other side is arguing, and hopefully they can reach a consensus on it. And with that, I think Jim's going to say a few words, and he'll go through some of the details in the bill.
Thank you, Clint. Thank you, Chairman. Jim Thornton with GMA, and I would certainly echo Clint's comments, thanking Chairman LaHood and Chairman Ginn, as well as the members of the Joint Study Committee for working on this. The goal is, as Clint said, to improve the process as is already in law with SDS. The General Assembly's recognized that the issues vary across the state, and you can't have a one-size-fits-all service delivery model. But what we're trying to do is make sure that the process hits those same goals that Clint alluded to, that they be less contentious, less hostile, more transparent. We think that will result in a better result on the local level for the residents of the cities and the counties. To walk you through the details of the bill, I'm not going to go into, as Chairman LaHood asked, I'm not going to go into as much, I can go into as much detail as you like, but I'm going to try to hit the high levels and walk through it. In Section 367021, line 30, we begin by talking about the cycle. Currently, the cycle for SDS negotiations is managed by DCA. That will not change, and it will follow the comprehensive planning process. Every city and county is required to go through a comprehensive planning process, and we think you plan first, and then you decide how you're going to deliver services and pay for them. That will not change. One carve out in line 39, we are dealing with the fact that consolidated governments really don't need to go through this process, because if there's no one to negotiate with, it kind of becomes an unnecessary extra burden on the paperwork of the 10 or so consolidated governments across the state. If you move into section 3670.22, we have tried to put a timeline in law that everyone will be able to follow, that DCA will be able to administer, and that cities and counties will be able to comply with a reasonable time frame, where each year that you are required to do this on a 10-year cycle, when your year comes along, it would begin sometime in the second quarter of the year, sometime between April 1st and July 1st, or as necessary in line 47 through 51, if there is a change, a substantial change, a triggering event that results in a new service being created, a new city being formed, something that a change in revenue distribution, that there is a process for amending during the cycle as needed. If you turn over to line 70, this is something that Clint alluded to, that both GMA and ACCG felt very strongly about. This requires transparency. It requires the cities and the counties within 60 days of the initiation of the process to come forward with a written proposal. So this would be a written proposal that analyzes both the components required as well as the criteria that are required by the Act, and providing factual information, data, and analysis. This, as a public record, would be available, obviously, to the other parties, and it would be available to the community, and it would give it would basically force cities and counties to show their hand, to put all their cards on the table, not wait until some sort of subsequent litigation or dispute process. As we move forward, I would just point out that on lines 143 through 152, we do not change what is current law, which would be who has to sign off on the agreement. So there's often sometimes some questions about that, and it is a requirement that for an SDS, it has to be the county, any city over 9,000 population, the county seat, and then at least half of the remaining municipalities. So there's a provision in law to make sure that everyone has a voice, but that small cities can't hold the process hostage, and we're not changing any of that. There are a lot of deletions in this bill, beginning on pages 8 and 9. This is where we are trying to simplify the current dispute resolution process, which Chairman LaHood alluded to, sometimes results in a litigation being filed for purposes of causing a mediator to be appointed, and the judge stays the sanctions pending the outcome of that mediation. We've seen examples of that lasting for multiple years. That language is being removed, and instead, going back to lines 167 through 171, there will be a mandatory mediation process that will start after 90 days. So the negotiations begin, written information is exchanged. If they haven't come to an agreement, then there's a mandatory mediation process. But that mediation is limited only to those issues that are in dispute. So you can't go into mediation and just open up all the issues. You have to identify what are the issues in dispute. That is a mandatory process. But then if you look over onto beginning on lines 232, there's a new provision for an optional arbitration process. And I do want to clarify that this is very clearly stated in line 237 to be a non-binding arbitration process. So this is not intended to be an arbitration that makes a ruling that gets enforced by a judge. It's a non-binding process. But the carrot, if you will, for cities and counties to go into the non-binding arbitration is they get an extra 6 months extension on the deadline. And what will end up happening is the arbitrator will present a written report that we think will be, again, while not binding, we think it will be persuasive authority. It's almost like an opinion from a neutral third party that one party's being reasonable, one party's being unreasonable in the process. And then Chairman LaHood mentioned the sanctions. That begins on lines 272, where if the local government does not verify strategy, then sanctions would be imposed on the first day of the month after the deadline, and that could be either the original deadline or a 6-month extension if they went into arbitration. But I want to very importantly point out lines 303 through 311, because this does allow sanctions to be stayed in the event of a state of emergency, a natural disaster, something that affects health or safety, or a court order. We know that obviously during the COVID emergency, some of these deadlines were extended. We know that natural disasters occur, and that's through, these are intended to be things that are through no fault of either the city or the county, that more time is needed to complete the agreement, and so the sanctions would be held in abeyance. And then the last thing I would just point to is I mentioned triggering events which would allow for a negotiation to occur during the cycle, during a cycle, and we have left that mostly unchanged on lines 316 through 325. This is like where you create a new city or you have a revenue distribution changes, et cetera. But we added in line 326 through 332 a provision that if the change doesn't affect everybody, so like take for example a county with, the county and it's got 5 cities, but the change only affects a swap of territory between 2 cities. You don't have to open up the entire process. You can just allow those 2 affected governments that are involved to negotiate and not have to start from scratch. So with that, Mr. Chairman, GMA and I think ACCG as well, as Clint said, feel like while this will not be a panacea and will not solve all disputes, we think it will improve the process, still allowing local flexibility, local governments to decide what is in the best interest of their local community, but will do so in a way that is more transparent, less hostile, and does provide a meaningful dispute resolution process.
Well, thanks to both of you, and appreciate again all the work that's gone into getting this done. And I know it's not an easy task to get 159 counties and 500 plus cities to agree to policy, and I don't believe they do all agree 100%, but enough to advance legislation, we hope. So we have a question from Representative Bernal.
Thank you, Mr. Chairman. Just for informational purposes, what would be considered, since we've done a lot with new cities and then with the elections, like for example in our county we have 2 new mayors, we're going to have a new chair, we're going to have 2 new commissioners. What would be considered to be a service for them that they might think about, even though we already have established cities? So what's the service delivery that might be one that might?
I think the most prominent services would be water, sewer, okay, law enforcement, fire protection, those type of things.
Okay, and so this is for existing cities that are in counties, and then for also to help our new cities that we've voted on.
Right. If I'm not mistaken, a new city must deliver at least 3 services. They must pick at least 3 off a list of eligible services. That's one of the requirements of becoming a city.
Okay, thank you.
All right, thank you. Okay. All right. Representative Anderson.
Thank you, Mr. Chairman. I was just going to say, as someone who's participated in service delivery negotiations and representing a county that was unable to, well, one of the counties I represent was unable to reach those a SDS agreement for many years. I applaud you and the study committee for this bill coming forward, and appreciate the participation from ACCG and GMA on this. And at the appropriate time, sir, I'd like to make a motion.
All right, we got one more question from Representative Maynard.
Thank you, Mr. Chair. I appreciate the bill. This is probably, at least I've been up here for 2 terms, and we've studied this issue all 4 years that I've been here, and so thank you for the work that you put into the bill.
Thank you for that, and you too, Representative Anderson. And I'd like to recognize City Council member Tim Carroll from my hometown, Valdosta, and City Manager Richard Hardy with us today, and they've had a lot of input into this process, as well as Lowndes County, one of the counties I represent. So appreciate the input from them, as well as a lot of other local governments, and again, all the work that's gone into it from the committee members and the two associations that represent all of our cities and counties. So I believe we have a motion.
I move to pass.
We have a motion. Do we have a second? We have a second. All in favor, say aye. Any opposed, say no. All right. Thank you. It moves. All right. Next, we've got Representative Bethany Ballard. You here? House Bill 1121 on short-term rentals. Tell us about this bill we've all heard so much about lately.
I'm sure you have. Thank you, Mr. Chairman, members of the committee. I've got HB 1121. I've got LC 365791S. This bill protects private property rights of our citizens and balances the needs of our local governments with one of our most sacred rights, which is our right to our property. And this is simply grandfathering legislation which will allow property owners to keep their current short-term rental units if a local government were to ban them, and it will protect a source of income that many people count on. I have worked with GMA quite a bit, and we reached compromises on a lot of the language in the bill. There is a 3 strikes rule. If there are 3 valid complaints against the short-term rental, the local government can suspend that rental for 1 year. After the 1-year suspension, if there's one more complaint, the permit may be pulled forever. If the property is sold, the new owner is not entitled to assume that short-term rental designation. The new owner would have to abide by any rules and regs that the community may have. It does not prevent a municipality from creating any rules and regulations that govern short-term rental units going forward. And it doesn't prevent a local government from banning new short-term rentals. It just grandfathers in the ones that were already there. And there is some language in there starting at line 135 that it does not infringe on any HOA rules or covenants. That was requested to be put in. So that's all, Mr. Chairman, and I'll be happy to take questions.
All right.
I know it's been a long day.
Yep, so we do have at least one question, and we have several members of the public here to speak to. So we'll start with Representative Brad Thomas.
Thank you. My question is lines 48, you say, well, I guess 48 through 52, say specifically prior to the date of enactment of the local regulation by local government body held out the property to the public for use as short-term rental unit and prior to the first date of the use of the property. How do you actually know when that is? What's to stop me from coming in and saying, well, I've rented my basement out 2 weeks ago, so I'm good?
Well, I think, and that's, one of the tricky things. I think some of our communities have been really proactive on the short-term rental issue and have kept up with it in their communities, and some have not. And so I think that is one of the trickier points of this. And, I've kind of said this is all this new stuff we've got going on with, lots of our issues now. We are changing so fast as a society that it's hard for our municipalities to keep up and hard for us to keep up with some of the fast-moving changes. I think that there would be, I think that that's what a community would have to kind of determine themselves.
All right, thank you. Mr. Chair, I'll hold my questions until after the speakers.
Okay. All right, next we've got Representative Gullett.
Thank you, Chairman. Thank you, Representative, for the bills. So how does, from an enforcement standpoint, so if I'm suspended, how does a government, say I'm temporarily suspended, it's not permanent suspension, like how does a government nuance that? Like how do they enforce that?
I do not know how they would enforce that. That would be up to the local municipality. That was some language that GMA had wanted in there.
Okay. So I hear you saying GMA a lot. Is ACCG opposed to it? GMA?
I only met with ACCG one time toward the end of this process, and they seemed to indicate that they weren't a huge fan, but they were kind of on board with what GMA had asked.
Okay.
So, but I met with GMA a lot throughout this process.
Thank you.
Representative Bernal.
Thank you, Mr. Chair. Thank you for the bill. Does this include pad splits?
I'm sorry?
Does this include pad splits?
If that is included in any of the short-term rental designations, and no, it wouldn't actually, it would not include that.
So no one could come in and cut a house, split it up so that they could go from being a 2-bedroom house to a 6-bedroom house?
No.
Okay, thank you.
Representative Olalaye.
Thank you, Mr. Chairman. Thank you, Rep. Quick question. Would this create, I'm trying to wrap my head around the treatment of those individuals who would be grandfathered in versus those who would be new entrants into the STR marketplace. Administratively, how do you imagine cities and counties treating those two very different categories?
Well, there's a date in the bill of July 1.
But this bill is saying that anyone grandfathered in would be exempt. But if you're not being grandfathered in, you would be subject to this.
To the rules and regulations that your municipality has.
So you have two separate groupings of individuals who would be treated differently per this.
If that is what the municipality decided on.
Got it. Can I ask one more question, Chair? Thank you. I think on principle, I always feel that cities know best, and it's hard to get behind blanket mandates, and I'm not against the spirit of the bill. It's the home rule aspect that we're skirting over that gives me some heartburn.
And I struggled with that because I generally think that home rule and local control is best, but when it infringes on private property and something that has been allowed and something that's been legal and something that people have been relying on maybe as part of their family budget, I think that's where those two things kind of come and clash a little bit. Because, you know, I hate to sound like a 4-year-old, but when you say it's not fair, but it's not fair for somebody to take away part of your family budget that has been legal up until that point.
Do you think that we at the state are best positioned to tell you and your community how best to address this issue?
Maybe when the community is trampling on the rights of individuals and their private property.
Okay. Thank you, Rep.
All right. We're going to take one more question, and then we've got several members, I think about 10 members here of the public that want to speak to this bill. So, Representative Maynor. You number 8 or 9? Try again.
Thank you, Chair. 2 questions for you.
Yes, ma'am.
One, I just don't know the answer. Do cities or counties, who has a greater propensity of governance over short-term rentals? City, municipalities, or counties?
I think that cities have more governance over those.
And then if I may follow up, so this bill as a property owner rights bill, within the legislation, the way it's written, it does say that if the property owner does not abide by these rules, they cannot use their property as a short-term rental.
Like if it's a problem, like if the police are getting called, that's when that 3 strikes comes in, if it's a nuisance property.
And so really this bill, I'm asking, this bill, the intention is for law-abiding, non-problematic, short-term rental owners.
Yes.
And trying to create a fix for people that are short-term rental owners that have been causing problems in their community?
Mm-hmm.
Asking.
Well, so I think, now that some municipalities are trying to just ban them across the board. And so what this bill seeks to do is to make sure that those people who have had a short-term rental in that community are allowed to keep it with these kind of stipulations that they cannot, be a nuisance property. If it's a problem, if the cops are getting called, that's when that 3 strikes comes in.
All right. Representative Bernal, I'm going to let you ask a quick question, and then we'll go to the public.
Thank you, Mr. Chair. Okay, I'm just a little confused. How does the city know that you are a short-term rental?
Well, you should have been paying your tax on that.
Because a lot of these, the city doesn't know, or you don't find out that they have turned their property into a short-term rental until something happens, or someone happens to notice there are more cars there. So I'm just trying, my house, I have 1, 2, 3 bedrooms upstairs. I have a basement. If I decide today when I walk out of here, I'm going to start renting out my rooms, I wouldn't have gone and said anything. But then if my neighbor finds out and they start to complain, I'm not registering. I'm just trying to understand how you would know.
So you're supposed to have registered. You're supposed to be paying your taxes. It's been a long day. Hotel and lodging taxes to your municipality. So the cities should have that data already of who has a short-term rental.
Okay. So if they have not been doing that and they have not been paying those taxes, then they would not be grandfather claused in. Is that right?
Yeah.
Okay.
If they haven't been abiding by the regs that are there previously, yeah. So this is to protect these people who have been law abiding and who are now trying to have it taken away from them.
Thank you.
Does that make sense? Okay. I feel like I'm not being as clear as I could have been maybe at noon today.
Representative Ballard, I know you've worked a lot with a lot of stakeholders and tried to solve a lot of the concerns that you've heard. So appreciate all your work on it. And what we'll do now is just start hearing from those that have signed up to speak. And because it's so late and there's so many speakers, we're going to limit the comments to 2 minutes each. So we'll start with, let's see, Noah Reitz. Come on
Thank
up.
you, Mr. Chairman.
Yep, thank you. Yeah, if you would just introduce yourself, tell us who you're with, and I will start the clock.
Thank you, Chairman, members of the committee. Noah Rainitz with the Georgia Municipal Association, and I'm joined by the mayor today. Mayor, please introduce yourself.
Thank you, gentlemen, for taking the time to hear me. My name is John Howard. I'm the mayor of the city of Monroe, Georgia. Would you like me to go ahead? Okay, I've been talking over the last several weeks with our Legislative Policy Council, made up of mayors from around the state, small cities, big cities. Also talked with attorneys who reviewed this bill and my actual CPA. We cannot find justification for a blanket short-term rental bill for the state. In Monroe, for instance, and I will be quick, we have a thriving wedding industry, but we have no hotel. Our ordinance is shaped based on the needs of our local population, and that may be different from the other 535 cities around the state. As cities, we work to protect the rights and freedoms of the citizens and our commerce, and we need our ordinances to remain individually tailored to our own municipalities. This gives us maximum flexibility to address ever-changing needs of our community. I appreciate your time. Thank you.
Thank you.
Yes, sir.
And if I could provide some quick comments, replies to some of the discussion I heard earlier. And I'd like to begin by actually thanking Representative Ballard because she really did entertain meetings with us and some of the concerns we brought on early on. As I'm sure each of you know from your work in the legislature, when you introduce a bill, there's kind of a first layer of concern, second layers of concern. As more conversations happen, more information comes to light. And that's a little bit about what happened here. But I do have to say, I'm thankful to her for working with us thus far. We just do have some concerns going forward. My primary concern does have to do with the grandfather clause. In the legislation, you'll see in Section C, the local regulation in effect on the date a property was first used as a short-term rental by a property owner shall be the applicable local regulation governing the use of such property as a short-term rental by such property owner unless that asset is transferred. So basically, you are grandfathered in. The concern being, local governments are preempted from having a rental registry. We are preempted from being able to identify rental properties within our jurisdictions. If we exist in a grandfather clause, every single time that city goes to edit, amend, or change their short-term rental ordinance in any form or fashion, you are therefore creating a new class of grandfather clause. Without the ability of the city to be able to identify short-term rentals that are operating within their jurisdictions, they would have no knowledge of what set of regulations they have that would apply to them. This creates a massive enforcement issue because we would have no idea what regulation applies to what short-term rental property because we'd have to identify the date at which that property was first offered. So with that being said, I think we just have some concerns about this bill. Representative Gullett, you asked a fantastic question. If somebody was offering a short-term rental and they weren't in authorization with the local government, that's considered a non-conforming use. That technically is illegal. There could potentially be small civil enforcements that would be tied to that, but that's what that would be. And back again to what Representative Ballard, when she was first speaking about the bill.
Let's try to wrap it up pretty quick.
Absolutely.
Over time.
Airbnbs has been around about 10 years. Short-term rentals have been around for about a decade. This is a fast-changing market. Our state is fast-changing. The most effective form of regulation for these properties is going to be derived at the local level, and I hope that you see that and hold off on this bill here today. So thank you all so much. I appreciate it.
Thank you for your testimony.
Thank you, Chairman.
Appreciate it. Next, we have Betsy Bradfield with the Georgia Realtors Association. All right. We're starting the clock over at 2 minutes.
Thanks so much, y'all. Betsy Bradfield with the Georgia Association of Realtors. Thank you, Representative Ballard, for bringing this bill. So we work a lot in local areas, and what we're seeing is that a lot of local governments around the state are outright banning short-term rentals or passing effective bans on short-term rentals through overregulation. And we believe that a property owner's right to rent out their property without burdensome regulation is included in your fundamental bundle of rights when you purchase a property. So this bill protects private property rights, as it is the right of the property owner to be able to rent out their property as long as it doesn't hurt anyone else. And we do hope that this bill and maybe future efforts bring clarity and uniformity in these regulations across the state to ensure that they protect private property rights while still allowing local governments to address the needs of their communities. Some of the issues that we see is that if a short-term rental owner owns a property in one county and next door in another, they could have two wildly different sets of regulations that they have to comply with. So we're just looking for clarity and uniformity across the state. The most common arguments against short-term rentals are already addressed through reasonable local regulations like trash, noise, and parking ordinances that the city governments can enforce, and city and county governments can enforce. In our opinion, you do not need a rental registry to actually enforce those, as you would treat all residential properties the exact same. So if there's a property with an owner who's having a wild party, we believe that you should treat them the exact same as you would treat a short-term rental. So like Representative Ballard said, you should also be paying your marketplace innkeeper tax to be in compliance with state law. And we believe that short-term rentals do offer a large amount of accommodations that some people want when traveling. So they allow families with children to stay comfortably and offer more accommodations than like a hotel would. They offer backyards sometimes, full kitchens, and more sleeping space without having to pay additional hotel rooms. We have a lot of travel nurses in the state, and they provide a great opportunity to live in the community that you actually work in and use a full kitchen to prepare their meals every day. So those are some of the reasons that we support short-term rentals, and we're looking for sensible regulation. We do not believe that there should be no regulation in the short-term rental market. We believe that regulation is absolutely acceptable and understandable. We just want to make sure that there is not over-regulation where you regulate a short-term rental out of existence. Thank you.
Well, thank you. Thanks for talking so fast. Next, Matt Campbell with Georgia Matters.
Chairman LaHood, members of the committee, thank you for the opportunity to come before you. My name is Matt Campbell. I have the privilege of speaking for the Georgia Realtors, but I think Betsy handled that very well. She didn't leave any stone unturned with her testimony. She did a wonderful job. So I'm speaking now personally as a short-term rental owner and someone that this particular legislation may save my property. So I'm commute back and forth for the session from Richmond Hill, Georgia, which is a suburb of Savannah, where I own a little house on Tybee Island that my wife and I, who both work about 80 hours a week, saved up for years. And we moved from Cobb County down there. Our dream was to buy a beach house and to make the payments on that house, the flood insurance, the high taxes, because it's at a beach, it's at a place where people want to go vacation. We rent it out, right? I wish I could have two houses and keep it, but I can't afford to have two, so I rent it and I manage it myself on Airbnb and Vrbo. And I guess a couple of years ago, that city that it's in, the city of Tybee Island, beautiful as it is, they enacted a short-term rental registration, which is first place a violation of state law in the beginning, and that goes all the way back, I believe, to the Civil Rights Act, where you're not allowed to create a rental registry. Well, that happened. Well, fast forward, and you all should have received an email from me of the committee meeting for the Tybee City Council last Thursday, in which I spoke right after the famous Savannah author Mary Kay Andrews, who owns a couple of houses around the corner from me. And so, and what you said, Representative, earlier about winners and losers are picking, who gets to do what and grandfathering in. So what this particular community done, now this is one community, but it's just a picture of what could be done when local governments are allowed to just do whatever they want with no regard to the people that own property there or any other rights people have. So the map, if you have property on the north end, a condo or house, or on the south end, or scattered where on that little island, you can continue. You can sell your short-term rental and that person can rent it out. But if you're in the middle of the island or in some other parts, even right on the sand on the beach, that new ordinance that we spoke out against this past Thursday would make it where if I sold you the property or gave someone the property or died and somebody got the property, they'd never be able to rent it again. The house behind the little one that I own, there's a house that I vacationed in when I was 2. It's my father's friends. They live in Statesboro. And so they're in the 80s now, the Andersons. Peach farmers and great people. They've had a house at Tybee forever, just as many people have forever.
Mr. Campbell.
There's only a couple of hotels. You have to stay in a house and rent it there, right? So anyway, long story short, this bill would just grandfather in folks like me and others who have invested heavily, and it's part of the fabric of their life. And like Miss Ballard said, some people rent out part of their suite, right, to make their mortgage payment. And so to take that away, to change the rules in the middle of the game is wrong. And I think the state should act so that we can kind of put a stop on this overreach of local government. Thank you.
Thank you, Mr. Campbell. Next, we have Steve Cavello with Lanier Beach Holdings.
So again, Steve Guello, Lanier Beach Holdings. Lanier Beach Holdings is an LLC personally held by myself. Been in litigation with my county for the better part of a decade in regard to short-term rentals. And the assumption that the county knows best and the city knows best, well, they know best for maybe the wrong reasons. There may be reasons like they're getting into the short-term rental business. They're taking over a park. They're bringing in a bunch of rental properties, that type of thing. There may be nefarious reasons. Maybe there's people in that locality that want things the way they were when they were kids back in the 60s, and they don't want to see new faces. There's a lot of reasons not to trust the local governments. How about giving citizens legal protection? In our code book, it says, my government can sue me for any reason in civil court. Guess what? They did. They sued me in civil court without a citation, without magistrate court, without any of this, in order to bypass the rules and the laws, basically. And how are they bypassing them? I have spent $200,000 defending the right and defending my property rights. And most citizens wouldn't do that. So the power of that local government, they can do anything they want. You've heard the saying, you can sue anybody for any reason. Why not add to the legislation, just like the cities and counties are fighting? Why not put something in the legislation that says you have to have a meeting, you have to try to work it out? I have a letter from the county attorney saying, I've received your information for vested rights, and I don't know what to do with it. So I will get back with you when I figure it out. 2 years later, in discovery, we ask, why didn't you get back with us when we gave you the information for our vested rights? The answer is, we are getting back with you. That's what this litigation is about. So it's abusive, and I'm looking to the state of Georgia to rein in local governments that are out of control and not assume that the citizens are causing a problem necessarily, because there are problems with the local governments at times too.
Mr. Bello, I appreciate your comments today, and
Thank
I
you
wish
very much.
wish we had more time. I appreciate you being a part of this process.
Okay.
And we have
I've left my name and number. If anybody wants more of the details, I'm happy to share them.
appreciate you.
Okay.
All right, next with ACCG, Martha Ravello.
Thank you, Mr. Chairman. My name is Martha Ravello, and I'm here on behalf of ACCG. ACCG opposes this bill. We do not support a short-term rental mandate on all of our 159 counties. I would like to introduce Ken Gerard, a local government lawyer who will speak on behalf of ACCG in our counties.
Thank you very much, Mr. Chairman, members of the committee. I appreciate being here and appreciate the opportunity to address you. I have both defended governments in STR litigation as well as advocated and enforced STR rules and drafted STR ordinances. And it's been interesting hearing some of the testimony today, and all well taken. It sounds, though, as I was listening, it reminded me of a traditional zoning hearing at a local government, and there's a reason for that it sounded like a zoning hearing before a local government, because this is a land use issue. This is a zoning issue. There is always a tension between impediments via zoning on private property rights and the individual property owners who want unrestricted use of rights. That is a constitutionally baked-in tension. And the Georgia Constitution, the people of the state of Georgia have vested the power of zoning in cities and counties. It is not accidental that the moniker that even the author of this bill mentioned was, this is a grandfathering bill. Grandfathering is a zoning, that's a zoning term. And it is my very respectful position at the outset that having a bill by the State General Assembly that says to local cities and counties, you cannot address this extremely important land use issue at the local level is not only, with a lot of respect, incorrect, I would argue it is impermissible. There is not a one-size-fits-all solution with respect to the short-term rental issue. It's not accidental that many of those destinations that have a hospitality focus have adopted their own STR regulations, and I will further submit to you that each of them are different. There's a reason for that, because local elected officials have determined that these are the rules that are best equipped for their citizens. These are typically citizen-driven. In other words, the boards are acting based upon citizen complaints. And they craft legislation that is uniquely intended to address those issues. In addition to that, short-term rentals, they gobble up the stock of single-family residential dwellings in that jurisdiction. It is interesting to me that it sometimes seems like the state, on the one hand, is talking about workforce housing and wanting to ensure that there is this stock of residential dwellings such that people, service providers in these governments can live and work in the same jurisdiction. And then on the other hand, I've got governments literally that are saying the STRs gobble up the stock of single-family residential because institutional investors and REITs and other sorts of moneyed interests can make a fortune on this product. And so I just want to focus on that as well. The grandfathering issue here.
Mr. Gerard, if you could start wrapping up.
I will. The last thing I'll say is this. The notion of grandfathering is about to be statutorily baked into the law. But under the common law, a grandfathered right can be taken away after a reasonable period of time. This would upend what has been a time-honored concept under Georgia zoning law if this were to be adopted. So I have more, but those are some of my more significant issues, and I'm happy to address any questions, Mr. Chair, should you have any.
Okay. Thank you. Thanks for your testimony. Thank you. All right, next we've got John Jared. I believe I'm pronouncing it right. Yep, come on up. Just tell us who you're with, and I'm going to reset the clock at 2 minutes.
All right, well, thank you, Mr. Chairman. We're only going to need about 30 seconds, but in the interest of time, we're going to do a 2-for-1. I'm Chris Hardman. I'm with the Georgia Hotel and Lodging Association, and again, knowing the hour is late, I wanted to introduce my good friend, John Gerard, with the American Hotel and Lodging Association, who's been working tirelessly on this issue, not just in Georgia, but throughout the Southeast. So with that said, Mr. Chairman, John Gerard.
Thank you so much, Chris, and thank you to Chairman LaHood, and thank you to Representative Ballard for bringing the bill. No relation to the former Gerard, although I wish I could speak as eloquently. My name is John Gerard. I'm Director of State and Local Government Affairs for the American Hotel and Lodging Association. And don't worry, Chairman, I have my own clock going, so I know I've got about 80 seconds left. So I'll just give you a couple of quick numbers. In the state of Georgia, we work with a group called All the Rooms, which is an objective data compiler that shows how many short-term rentals are listed within a particular state. There are 30,115 registered short-term rental units within the state of Georgia. Of those, 14,607 are being run what we call professionally. That means there are at least 3 or more units that an independent LLC is running. 3 or more units within an area, I don't care if it's rural, urban, etc., that is running a small business. That is creating moderate to above moderate income per annum. And while we respect everyone's property rights, I work in 6 states in the Southeast. We by no means want to infringe on someone's property rights, but this is not 50% of these units are not mom and pop operations who are creating subsidiary income for a mortgage payment or for a college tuition. These are ones that are making borderline commercial investment and having commercial return. And to have this type of blanket zoning immunity for one business while not giving any sort of regulatory oversight or thought to any other business from within the state and hold it to the same standard just doesn't make a lot of sense. And while I think the representative said it best, we understand and appreciate the spirit of what this bill is trying to accomplish. We can't support the zoning aspect of what this is bringing. Thank you so much, Chairman. Thank you to the representative again. Thank you to everyone involved, and I yield the rest of my time.
Okay. Thank you. All right, next we have Nadia Giordini. Nadia, sorry for the mispronunciation. Come on up. Thank you, and you've got 2 minutes.
Thank you, sir. Thank you, Mr. Chairman. Thank you, committee members, and thank you, representatives. My name is Nadia Giordani. I live in Cabbagetown, and I have a short-term rental. I support this bill. Living in the city of Atlanta, it's hard for us to keep up with all the changes all the time with legislation. Some are for, some are against. As you all may know, that we have a zoning law that went into place 2 years ago. It's never been implemented. We've all paid our fees, we've applied for our licenses, and nothing happens. And I understand that there are some problems with short-term rentals. We talk about investors that come in and take over our neighborhoods, but why don't we address those issues and not make it a broad issue that penalizes individuals like me? I have a daughter that I've raised in Cabbagetown, just graduated from college, and I'm able to stay in my neighborhood because I do short-term rental. So I'd like to express my support. And I know that we were talking about grandfathering, and there are ways to detect who the short-term rentals. Many municipalities have had host register, so there are ways to find out who's been hosting for a while. And also, I'd like to add that I am a volunteer community leader with Airbnb, and so therefore I speak to hundreds of hosts. I have 2,000 short-term rental Airbnb hosts on our Facebook page. And I hear their frustrations about what's going on in their cities and how they feel like they have no control. People who wake up one day and all of a sudden it's illegal for them to have a short-term rental and they have to shut down. So we want sensible laws, guys. We want to do this in a good way, but let's not make it all or nothing. So I totally support this. I thank you very much for your time.
Thank you, Mr. Giordani. All right, next we have Arthur Sketman. Correct my pronunciation if I didn't get that right. All right, I'm starting the clock at 2 minutes.
Thank you, Mr. Chairman, members of the committee. I want to start off by saying that we wouldn't be the first state that's grandfathering in something like SB 1121. Tennessee's already done it. I moved here about 3 years ago from California, and one of the main reasons why I moved away from there was because it was an uphill battle of what this country, or the fundamentals of what this country was built on. I was being told what I can and cannot do with my property, how many days a year I can rent it out on a short-term basis, and basically there was no point of continuing that battle. I decided to move to a state where I can feel like an American citizen, and Georgia was that state. But when I got here, I realized that some counties had no rules or regulations or any kind of a language on what can and cannot be done on a short-term rental basis. And then I found Hall County. Hall County had a set of rules that, if you play by them and you follow the instructions, you get the permits, you pay a business license, the taxes, and pay for the license itself, you can operate your short-term rental. And that was very, very important for me because I didn't want to operate in a county or city where there was no language at all. Because then you have, one day the city or county comes in and just takes those rights away from you as a homeowner. So I support this bill very much. I think I only see positive things, and I appreciate everyone that's worked on this thus far. Thank you very much.
Thank you, and I appreciate that. That concludes all of our testimony from the public, and I appreciate all the engagement in this process. I want to see if we have any more questions from the committee at this time. It looks like Representative Maynard does have a question.
Thank you, Chair. Just a couple questions for the author. So on line 79, I'm a little conflicted because in one breath we're saying we want to protect the rights of the property owner. 79 says suspend for a year, and then 81 says permanently ban. And then lines 84 through 86, it brings up the burden of proof. But other people have already mentioned that everyone doesn't register their short-term rental. So how would she explain those things?
Representative Ballard, would you like to respond from your chair?
Yes. So the first line, let me deal with the first one, which is that 3 strikes law. GMA had requested that because, this is a balance between protecting the rights of the property owner and their source of income, and protecting our cities. I love my city as much as everybody loves theirs. I want to see it be the best it can be, and so this would allow our municipalities to deal with a short-term rental that was a problem. And so that was the language that, and GMA and I went back and forth on that, and that was a compromise on both of our sides, and so that just allows them to deal with that. And as far as taking it away completely, the property owners who are, really, they love their house that they're renting out. They rent it out probably because of a necessity, so that they can have that vacation house like we heard in testimony. They're not going to be the ones that are going to break these rules, and it's going to, allow others to break the rules. But we did need to give our municipalities a way to enforce that and make sure that their city was staying as good as it could possibly be. And if you forgive me, what was your second question? It has been a very long day.
Well, the second question was related to lines 84 through 86, and I guess also 101 to 104, which if people are not registering their short-term rental, and if a municipality or a county, flag them for some reason, and then they can sue the county or sue the municipality, I just see a conflict if the city or county is trying to abide by the law, but they never even knew that it was a short-term rental to begin with. It just seems contradictory. I can't get past that. I'm sorry.
Well, and it does come from existing code, which does not allow registries. So you're having to go, look at the tax records, and so I understand that might be some of that confusion. But again, my goal in this was not ever to hurt our cities, but it was to protect property rights and those property owners. And I think we've heard, there is a lot of tension in that.
All right, we have a few more questions that we'll move on to, and we can circle back if we need to. Representative Thomas.
Thank you, Mr. Chairman. One of my questions really has to do with the topic that we've discussed a little bit in this committee regarding workforce housing. And, one of the things that I question is the effect of institutional investors buying up existing housing stock. And how does this housing, workforce housing, how is this going to be affected by what it is that you're proposing in your legislation? Because right now people can't even get into a house, and we're sitting here and we're worried about people that have 3 houses, and I think maybe we're focusing in the wrong area. But
and I can see your point, but take for example our traveling nurse phenomenon that has come up in COVID. The traveling nurses, they have utilized Airbnbs quite a bit. And so I think that this is just one of the changes that we're seeing. I think that we can do this without hurting anybody. And I understand, some people do have 2 and 3 houses, but they've worked for those and they've bought them, and it's been legal for them to rent them out, and we shouldn't penalize them for being successful.
So, may I, Mr. Chair, one more question? The other comment that was made, and I'd like to hear your rebuttal, regards on the fact that right now, if a law is passed, you're already grandfathered in, and as I heard the testimony, it's for a certain period of time. Why is this needed if that's the case?
I'm sorry, can you repeat?
There was testimony provided, and where's the gentleman at that provided, the lawyer? Where was he at? Did he leave? There's testimony that was provided that said that if something like a law changes, they're already operating under a certain set of criteria, that they're already grandfathered into that system, right? So, Well, no, that's what I'm saying. They already are. That was the testimony that was given, and this is an opportunity for you to rebut that testimony. Is that not the case? I guess I'm confused, because if this is already grandfathered into this old system, why do we need a bill to be able to do it?
Well, I think if that were the case, I wouldn't have had, I've had some short-term rental owners coming to me and being concerned about this. So I think if it was already the case, I wouldn't have people coming to me as private citizens and asking for this.
All right, let's move on to Representative Gullett.
Thank you. So I know we talked about we can't do a list of rentals. Did you look into doing that? I mean, I know that we did this because of things of the past, a long time ago. Is that something that you looked at changing to create, to allow a city or a county to have rental lists, or is that something that was really a no-go from the start?
I think that it was kind of presented to me toward the end of this process when we had already done about 6 drafts of this bill, and I thought that, that was something that perhaps we could, look at going forward, but I had not considered it in the original.
Gotcha. Okay. Thank you.
All right. Representative Roberts.
Thank you, Mr. Chair. So let's see if I can help maybe clear some of this up. So yes, some ordinances require or provide for legal non-conforming uses when a law changes, obviously. I think the purpose of this is to provide a compromise where across the state, you're going to know that if you can prove, whether it's showing your ad on Airbnb or wherever, that you had a short-term rental prior to some new law going in, that you were grandfathered in, but that doesn't last forever. It only lasts until you transfer the property, and then it extinguishes anyway. So there is some provision there that that it's not going to be forever as well. So I just see it kind of as a compromise. It's not saying cities and counties can't put new laws in, but I don't wake up one day and have to go spend 10 years litigating over my vested rights that I had prior to that law coming into effect. So it's making a uniform law across the state. Thanks.
Thank you. Representative Bernal.
Thank you, Mr. Chair. I just have one more question for the author. Okay, first, when you were first speaking, you said it was to supplement income. Now you're saying that if they have a whole lot of houses, it's okay to start renting them out. So I'm a little confused.
Well, no, I mean, I was answering Chairman Thomas's question, Representative Thomas's question. You know, someone who has been successful and you know, maybe has been fortunate enough to be able to purchase a house in the mountains and a house at the beach. I mean, that is not outside, well, it's outside the realm of my family's budget, but I'm sure for a lot of people, they are fortunate enough to have those two houses. And, you know, their property rights should be protected just like their property rights at home. I don't think we should penalize people for being successful and being able to afford those houses. And, you know, sometimes the only way they can afford those houses that they use for their vacation, their family vacations, is to rent them out.
Thank you.
All right, Representative Collins.
Thank you, Mr. Chairman. I just had a comment. My friend here, Representative Roberts, she made one point that I want to just kind of rebut. I don't know that this legislation, making a one-size-fits-all across the state, is really what we need. Coming from a local government background, that's just my opinion, but I just wanted to share that. You know, each and every community throughout this state is unique and is different in many different ways. And, you know, I have some strong reservations about this legislation moving forward.
All right, thank you. And back to Representative Maynor, and then we're going to try to wrap this up.
Thank you, Chair. It is just such an important topic. I am not against the concept. I do think that we need to put a little bit more work into it. You know, since people are using this as a business, maybe we should look at incentives for doing it the right way. But I know in Atlanta, in my district, I have lots of constituents that are calling me about short-term rentals that most likely are not registered the right way, but they are bad actors in the space. I like the concept, but just the way it's written, I'm sorry, Representative Chairman Ballard, I won't be able to support it.
Thank you. So we've heard a lot of testimony on both sides of this. It's not a simple issue to solve. It's complex. You know, I relate to a lot of the folks that have testified. I own a short-term rental, and it would be problematic if the local government that it's in suddenly told me I couldn't use it for that anymore. So I do believe we need some solution, but I don't know that we are ready with that decision yet. It sounds like there needs to be more discussion. We're out of time before crossover day, and I don't think we have a consensus here. So we're just going to make this a hearing. And Representative Ballard, if you feel like you can gain a consensus, and there's still time this year, then come back to me and we'll see what the options are. But I appreciate all the testimony today, and hopefully we can continue to work on this with the stakeholders and come up with some proposals that we can get more consensus on.
Thank you so much, and I look forward to talking to everybody and working on this a little bit more.
Thank you. All right, next and last, we're going to hear from Representative Sarah Draper on House Bill 559. Representative Draper.
Thank you, Mr. Chair.
Hello, members of the committee. So very glad to be back before you again on House Bill 559, which is a bipartisan piece of legislation that you all passed unanimously last year from committee.
And Representative Draper, could you read your LC number to make sure we all have the right one in front of us?
Absolutely.
Yeah.
So we are now working off of LC number 472961S. So this piece of legislation very simply would take the guest time waiting game out of voting for voters who have babies and toddlers. If you have a baby or a toddler and you get to the voting line and there's a long line, you get to go to the front of the line, which is a courtesy that we already offered to our voters who are over 75 or that have a physical disability. Now, I have worked on this bill with the Speaker's office, and they wanted some changes which are incorporated in the substitute in front of you. So last year when we passed this bill, an amendment was made in committee to change the 75-year-olds to 70 years old. So to change that provision. The Speaker's office asked me to change it back to 75. And also what they have done is asked me to change the 5-year-old requirement down to 3 years old, so that we could make more of an incremental change, see how that works, and assess, go from there. So those are the changes to the bill, and I don't have any other comments unless there's any questions.
Representative Oliver? Okay. We have a question here from Representative Olalier. I'll get back to you.
Thank you, Mr. Chairman. Really a comment. I just wanted to thank Representative Draper for her work on this. Got a 2-month-old and a 2.5-year-old, and the voting process is a bit complicated with little ones. I really appreciate you narrowing the focus as it relates to age to really provide those most in need individuals and families with an accelerated process. So just thank you for your work on this, and happy to support it.
Thank you, Representative Olalier. And Chair, if you don't mind my saying, I know the hour is late, but we had several people here to testify with babies earlier today, and they did have to leave because it got late and they got hungry. So I just want to give them a shout out, especially little JJ, who was here most of the day. It does prove the point, doesn't it?
I did meet one of those babies on the rope line.
JJ.
I think her name was Josephine.
Yes.
Yep. So Representative Thomas.
So does this in any way have any effect on my Cherokee County State or Board of Elections?
On your Board of Elections?
Yeah.
No,
Okay,
I'm sorry.
that's
Would
good.
you want that?
I'm glad we're staying out of that one on this bill. Thank you. This is a good bill, and it makes sense. I appreciate it.
Thank you.
All right, we have a motion to pass. Do we have a second? We have a second. All in favor say aye. Aye. Any opposed say no.
Appreciate
it passes. Thank you.
Thank you very much.
And I know we had a couple folks here to speak to the bill, but I think they're waiving. So thank you. And Representative Oliver asked a question about the agenda tomorrow. I just had the room saved as a placeholder in case it's needed. Doesn't look like it'll be needed. So enjoy your day off tomorrow. All right, see you on crossover.